voluntary act, and that's something that the state has to establish. The evidence in this case presented by the state has shown that at the time both Mr. Prado and Mr. Zintek were wounded. This was in that second round, or the second cluster of shots. We had testimony that Stephen was injured, that there were people who were assaulting him. We had testimony yesterday from somebody admitting that he was in a headlock at the time. It was a chaotic scene. I would submit to the court that based on the circumstances surrounding the discharge of the bullets at both times when Mr. Prado was injured, so also as to Mr. Zintek, as to count 6 and 7, if we look at the totality of the circumstances, both with regard to the wound paths demonstrating the upward direction in which those bullets were shot, the fact that we have testimony corroborating that Stephen was on the ground, was being attacked, was in a headlock, he had injuries that have been testified to, we have pictures of that corroborate all that. The state has not presented substantial evidence that he voluntarily discharged the weapon at any of the occasions where Mr. Prado and Mr. Zintek were injured. So we ask the court to enter a directed verdict as to counts 4 and 5 and to count 6 and 7. As to count 1, Your Honor, the state has charged Mr. Jones with murder in the first degree under the legal theory that when Mr. Brew was killed, Mr. Jones acted with premeditation. There has simply been no substantial evidence presented by the state to demonstrate any reflection on behalf of Mr. Jones. No evidence presented by the state by which a reasonable juror could determine that the state has established premeditation beyond a reasonable doubt. What we do have is we have evidence, uncontroverted evidence, from the state's own witnesses indicating that Mr. Brew was anywhere from a couple inches to a couple feet from Mr. Jones at the time he was fired upon. The state will make the argument that that's from the muzzle of the gun, but that ignores the fact that Mr. Jones' hands are on the gun at the time. So we have a very short distance between Stephen and Colin at the time the shots were fired. We also have the angle of the wound paths. Medical examiner, I think, was very clear that the wound paths were an accurate reflection of the trajectory of the bullets from the time they left the muzzle of the gun to the time they reached their final resting place in Mr. Brew's body. There's no way to look at those trajectories against the backdrop of Dr. Zarnecki's testimony and not come to the conclusion that Mr. Brew was leaning, lunging, whatever description you want to call it. His body was rotated at a very aggressive angle at the time Stephen fired those shots from a demonstrably short range. We have absolutely no statements that have been attributed to Mr. Jones. In fact, I think this is something that the state has been, pretty particular about in establishing. We have no statements established coming from Mr. Jones prior to the shooting indicating that he was going to shoot, or he had a gun, or otherwise externally manifesting his decision that he was going to fire the gun prior to the shots being fired. There's been no evidence that he was verbalizing anything, making any threats, saying anything to indicate that he had the intent or already made the decision to discharge his weapon prior to the time that actually occurred. The reason that all this is important, Judge, especially when we also look at Mr. Peering's testimony, who himself was as close to Mr. Brew when Mr. Brew was shot, both in distance and in time, that essentially the two of them were approaching Stephen at the same time. All of this adds up to just one thing and one thing only, and that's a finding that if anything you have an incident where Stephen fired his gun as a result of a sudden quarrel. If we look at 13-1101, when we look at the definition of premeditation, the statute specifically excludes a situation where the act is a result of a sudden quarrel from premeditation. If we look at the evidence in this case, in a light most favorable to the state, at best, that's what they have. They've not demonstrated premeditation. It's no surprise they barely got past the grand jury with that count. And this is why we have a Rule 20, Judge. This is why the court needs to intervene and put its foot down and say there's simply not been enough evidence for this case, for this charge to go to the jury. and to enter a directed verdict pursuant to that rule.
Thank you, Mr. Davidson. Mr. Barker.
Thank you, Judge. Is it all right if I sit down?
Sure.
Thank you. I'm just looking through the indictment and looking at the language here. Let me start first with counts 4 and 5 regarding Nicholas Prado. Nick Prado testified yesterday that when he looked at the defendant, he saw the defendant looking back at him, pointed the gun directly at him, and fired. So intent is inferred by his actions. Again, intent, it doesn't have to be established by direct sensory proof. As the court is aware, it can be inferred by all the surrounding circumstances and facts of the case. At a very minimum, what he was doing was acting recklessly when he shot into a crowd of people. But by Nick Prado's testimony, there is substantial evidence that he was targeting Nick Prado when he shot him. As far as Kyle Zentek, Kyle also indicated that he recalled from his memory that the light was shining on him steadily, and he turned to run, and he was fired upon in his back at that point, also showing that there was an intent to fire upon Kyle as well.
Can I interrupt you for just
Sure.
a second? Marie, there's a case on my desk. Would you get that case for me, please? Yeah, it's right on my desk. I'm sorry, go ahead.
Oh, sorry. As to count 1, first-degree murder, again, intent can be established by all the facts and circumstances. What we have here was that the defendant was punched in the face in the street. By everyone's account, he then disappeared. Shane McConnell, Jacob Mike, did not know where he was, and we know that he went to his car because he didn't have his gun with him prior to that punch. He went to his car, he opened up his door, he got the gun out of that nylon case and out of his glove box, as indicated by the evidence. He chambered around at some point. We know he turned on the light because Zach Volpo, Nick Prado, others have talked about this bright light coming from the direction of the parking lot. He had an opportunity to reflect. The definition for premeditation says specifically proof of actual reflection is not required. Now, as to the defendant's or the defense's second point that this was a sudden quarrel or heat of passion, he had over 240 feet round trip of an opportunity to cool off or to not react to the situation. What he did was he got his gun and he came back to the fray. The jury can make the inference that at the time he went to go get his gun, that 150 feet to his car, that he was reflecting. They can also make an inference that at the point he got his gun out, he was reflecting, or at the point that he went toward the group 90 feet that he was reflecting. And the jury could also infer that at the point he shined the light on the victims, Colin and Nick Peering, before any movement was made, because that's what the evidence established, people saw the light shining on them before they moved, that he was reflecting at that moment that if they moved toward him or decided to step up to him, that he was going to kill them, shoot them. And that's what he did. And so there is substantial evidence to support the indictment, and we ask the court to deny the motion. Thank you.
We have a lot of folks here, and I think it's kind of incumbent upon me to help the folks who are here kind of understand what it is that we're doing, because this might seem a little bit different. Under Arizona Rules of Criminal Procedure, we call it a Rule 20 motion. It's a motion that can be brought by defense or by the court on its own initiative to render a judgment of acquittal based upon the review of the evidence presented. The rule cites in part, states in part, on motion of a defendant or on its own initiative, the court shall enter a judgment of acquittal of one or more offenses charged in an indictment or information or complaint after the evidence on either side is closed, if there is no substantial evidence to warrant a conviction. And you heard both Mr. Davidson and Mr. Barker arguing about substantial evidence. I'm referring to State v. West, 226 Arizona 559. I was obviously I've been doing this for a while. I know that this motion is going to be coming. This is again State v. West, and it was a decision issued by our state Supreme Court, and it cites at head notes 3, 4, and 5. On all such motions, meaning the Rule 20 motions, the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And I'll leave out the other cites. The Supreme Court continues, substantial evidence. Rule 20's linchpin phrase is such proof that reasonable persons could accept as adequate and sufficient to support a conclusion of the defendant's guilt beyond a reasonable doubt. Both direct and circumstantial evidence should be considered in determining whether substantial evidence supports a conviction. And I read to the jury the instruction on direct and circumstantial evidence. They go on, the Supreme Court goes on under head notes 6 and 7. On the other hand, when reasonable minds may differ on inferences drawn from the facts, remember, direct or circumstantial, the case must be submitted to the jury, and the trial judge has no discretion to enter a judgment of acquittal. On the basis of the holding in West, I do find from the inferences that reasonable minds could differ, and therefore I have no choice but to deny the motion for acquittal on the charges. However, I will, if requested by the defense, entertain a lesser included offense of disorderly conduct with a weapon to the aggravated assault charges based on the evidence presented so far. Are there any other matters that we need to address before we recess for lunch?
Not from the state, no, thank you.
All right, thank you, folks. We stand adjourned.